Whoa. One, two, three, four, five. This is part five. This is cool. We read from here today. Two 55. Copy. Right. This is words on a computer. 255. Being on licensed premises outside licensing hours. A person commits an offence who on any day is found in any part of any licensed premises other than club premises that is used principally or exclusively for the sale, supply, or consumption of alcohol at any time that it is not a time when a special license applies to the premises and is not between 6 a.m. and the time when the next period of permitted trading hours for the premises begins. Hang on. Yeah. Begins and is more than 30 minutes after the required close for the sale of alcohol, or a time when the premises are required to be closed for the sale of alcohol. There we go. All right. A person who commits an offence is against subsection 1. Again, and again, a person, a person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $2,000. Subsection 1 does not apply to the license, the licensee's spouse, the licensee, or the licensee's spouse, civil union partner, or de facto partner. A manager's spouse, civil union partner, or de facto partner. A member of the immediate family of the licensee or a manager. An employee of the licensee who does not live on the premises during the hours he or she is employed to work on the premises, and for 60 minutes after those hours have ended. A person who is the agent of the licensee or acting under a contract with the licensee or a manager and has the authority of the licensee or a manager to enter the premises, to clean, repair, or restock the premises or any equipment in them, or to check or remove cash. Whoa. A person who has the authority of the licensee or a manager to enter the premises to remove equipment, for example, banned equipment. An employee of the licensee who lives on the premises. A person who lodges on the premises. A genuine guest of a person described in paragraph 1 or J, I or J, no, I or J. Those people while that person is on the premises. Subsection 1 does not apply in respect of a person who is found on any premises where an on-license is in force if a special license is also in force for those premises at the material time, and that person's presence is on the premises at the time, and that time is justified in terms of the special license. Cool. 256. Allowing people on licensed premises outside licensing hours. A licensee or manager of any licensed premises who allows a person to be on licensed premises in contravention of Section 255 commits an offence. A person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $10,000. 257. Offences relating to evidence of age documents. A person commits an offence who presents to the licensee or a manager of any licensed premises or to an employee of the licensee a document that purports to be an approved evidence of age document, but it is not, or a genuine approved evidence of age document in relating to the person but containing, whether because false information was given to the person issuing it or information it contained when it was issued was later falsified, false information purporting to relate to the person's age or date of birth, or a genuine approved evidence of age document containing more information relating to some other person. That's quite funny. A person commits an offence who sells, hires, lends, or gives any part or gives to any other person a document that purports to be an approved evidence of age or document, but it is not, or falsifies information on a genuine approved evidence of age document relating to the age or date of birth of the person who whom the document relates. A person commits an offence without reasonable excuse, who, without reasonable excuse, sells, hires, or lends, or gives to any other person a genuine approved evidence of age document relating to the other person, but containing falsified information purporting to relate to the other's person's age or date of birth, or a genuine approved evidence of age document containing information relating to a person other than that other person. A genuine, I just read that. A person who commits an offence against this section is liable to, on conviction, to a fine of not more than $2,000. Licensees' offences in respect of manager. A licensee who fails without reasonable excuse to do any of the following commits an offence. Appoint a manager as required by Section 212 or 213. Ensure that Section 214 is complied with, which was this one, manager to be duty on all times. And comply with Section 231, which was appointment of manager, temporary manager, active manager. A person commits an offence against subsection 1 is liable on conviction to a fine of not more than $5,000. Failure to comply with requirement or restriction. Number 259. Failure to comply with certain requirements and restrictions imposed by or under this Act. A person commits an offence who fails or refuses to comply with any of sections 46 to 63, 150 to it is bing bong. Person commits an offence who fails to or refuses to comply with sections 46 to 63, 150.2 and 231.1, or any requirement or prohibition imposed by regulations of a kind described in section 3982 or 401 made under section 3971F with OBS. I read that. A person who commits an offence against subject 1 is liable on conviction to a fine of not more than $5,000. What? Cool. Infringement offences. 260. Infringement offences. In sections 261 to 264, infringement fee in relation to an infringement offence means an amount not exceeding $1,000 prescribed for the purposes of this section and regulations made under this Act. Infringement offence means an offence that is an offence against any of the sections 243, 244, 245, 250, 251, 254, 257, and 259, or an offence against section 258 1b relating to a breach of section 214 3. Specified infringement infringement offence means an offence that is an offence against any of sections 250, 254, and 259, or an offence against 258 1b relating to a breach of section 2143. 261. Commission on infringement offences. A person who is alleged to have committed an infringement offence other than an offence against section 259 may either be proceeded against or the alleged offence for the alleged offence by filing of a charging document under the Criminal Procedure Act 2011, or be served with an infringement notice as provided under section 262. A person who is alleged to have committed an offence against section 259 may be served with an infringement notice as provided in section 262. Infringement notices. If a constable observes a person committing an infringement offence, or an inspector observes a person committing a specified infringement offence, or he or she has reasonable cause to believe that such an offence is being or has been committed by that person, an infringement notice in respect of that offence may be served on that person. Any constable or inspector, not necessarily the person who issued the notice, may deliver the infringement notice or a copy of it to the person alleged to have committed an infringement offence, personally or by post, addressed to that person's last known place of residence. For the purposes of the Summary Proceedings Act 1957, an infringement notice or a copy of it sent to a person under subsection 2 is to be treated as having been served on that person when it was posted. Every infringement notice must be in the prescribed form and must contain the following particulars. Such details of the alleged infringement offence as are sufficient fairly to inform a person of the time, place, and nature of the alleged offence, and the amount of the infringement fee, and the address of the place at which the infringement fee may be paid, and the time within which the infringement fee must be paid, and a summary of the provisions of section 2110 of the Summary Proceedings Act 1957, and a statement of what will happen if the person served with the notice either pays the infringement fee or nor requests a hearing, and any other particulars that may be prescribed. If an infringement fee notice, and if an infringement notice has been issued under this section, the procedure under section 21 of the Summary of Proceedings Act may be used in respect of the offence to which the infringement notice relates, and in that case, the provisions of that section apply with all necessary modifications. 263. Payment of infringement fees. All infringement fees are paid in respect of infringement offences must be paid into a Crown bank account. That is like a bank account with a crown on top of it, just in case you didn't know. Regulations. The Governor-General may, by order in council made on the advice of the Minister, make regulations for all or any of the following purposes: prescribing the infringement fee payable in respect of infringement notices or offences, prescribing the form of infringement notices and the reminder notices for infringement offences, and any other particulars to be contained in infringement notices and reminder notices. Regulations under this section are secondary legislation. See Part 3 of the Legislation Act 2019 for publication requirements. And then there's that, which is 265. Closure of premises. Closure of premises by order. This section applies if a riot occurs or there are reasonable grounds for believing that a riot may occur in any place. A district court or judge or any two or more justices or any one or more community magistrates may, at the request of a constable, for the time being, acting in that place, order every licensee in or within a specified distance of that place to close his or her licensed premises for the sale of alcohol during the time specified in the order, which time must not be later than 24 hours from the end of the day on which the order was made. Any constable may use any force that may be necessary for the purpose of closing any licensed premises to which the order applies. A licensee or a manager of any licensed premises to which the order applies who keeps the premises open for the sale of alcohol in contravention of the order commits an offence and is liable on conviction in the case of a licensee to either or both of the following: a fine not more than $10,000, or the suspension of the licensee's license for a period of not more than 7 days. In the case of a manager, a fine not more than $10,000. A person who sells any alcohol on or from any licensed premises to which the order applies at any time while the order is in force commits an offence. A person who commits an offence against subsection 5 is liable on conviction to a fine of not more than $3,000. 266. Closure of licensed premises by police. This section applies in the following circumstances: if a riot is taking place or there are reasonable grounds for believing that a riot may occur on any licensed premises, or if there is fighting or serious disorder, or there are reasonable grounds for believing that fighting or serious disorder is about to break out on any licensed premises, or if there is a significant threat to public health or safety, or if the conduct on any licensed premises okay. Or if the conduct on any licensed premises amounts to a substantial public nuisance, or if there are reasonable grounds for believing offences that have been committed on the premises that carry a maximum penalty of 5 years or more, and there is a significant risk of further such offences being committed on the premises if the premises remains open. A constable may order the closure of any licensed premises or any specified part of any licensed premises for the sale of alcohol until a time stated in the order, which time must be not later than 24 hours from the end of the day on which the order was made. or or order any person to leave the premises or that specified part of them. Any constable may use any force that may be necessary for the purpose of closing the licensed premises or any part of the licensed premises. As soon as an order has been given, the licensee or a manager may apply to a district court judge or any two or more justices or any one or more community magistrates for the revocation of the order. We're up to there's 5. The judge or justices or the community magistrate or magistrates may revoke the order either unconditionally or subject to any conditions as he or she may think fit to impose, or may refuse to revoke the order. A licensee or manager of any licensed premises to which the order applies, who keeps the premises open or the specified part of them open for the sale of alcohol in contravention of the order, commits an offence. A person who commits an offence against subsection 6 is liable on conviction in the case of a licensee to either of or both of the following: a fine of not more than $10,000, the suspension of the licensee's license for a period of not more than 7 days. In the case of a manager, a fine of not more than $10,000. A person who sells any alcohol on or from the licensed premises or the specified part of the licensed premises at any time while the order is in effect commits an offence. A person who commits offence against subsection 8 is liable on conviction to a fine of not more than $3,000. $3,000. What's happening? Cool. 267. Powers of entry on licensed premises. Cool. A constable or an inspector may at any reasonable time enter and inspect any licensed premises or any part of any licensed premises to ascertain whether the licensee is complying with the provisions of this Act and the conditions of the licensed premises. A constable or an inspector may at any time enter and inspect any licensed premises when he or she has reasonable grounds to believe that any offence against this Act is being committed on those licensed premises. For the purposes of exercising the power conferred by this section, a constable or inspector may require the production of any license or any book, notice, record, list, or other document that is required by this Act to be kept and examine and make copies of it, and require the licensee or manager to provide any information or assistance reasonably required by a constable or an inspector relating to any matter within the duties of the licensee or manager. A person commits an offence and is liable on conviction to a fine of not more than $2,000 who, without reasonable excuse, refuses or fails to admit to any licensed premises any constable or of any license premises any constable or inspector who demands entry under this section or delays unreasonably in admitting it to any licensed premises, and any constable or inspector who demands entry under this section. A person commits an offence and is liable to a conviction to a fine on conviction to a fine of not more than $2,000 who being the licensee or a manager of any licensed premises without reasonable excuse, refuses or fails to produce the license or any document when required to do so under section 1(3)(a), or to provide any assistance or information when required to do so under subsection 3(b). 268. Power to seize samples of alcohol. This section applies where a constable or inspector has entered and is conducting an inspection of any licensed premises under section 267. If a constable or an inspector has reasonable cause to suspect that any person on the licensed premises is committing or is attempting to commit any offence against this act, he or she may seize without warrant for the purposes of analysis any liquid, including the container holding the liquid, in the possession of that person that is suspected of being alcohol. 269. Power of police to demand information. A constable who has reasonable cause to suspect that any person has committed or is committing or is attempting to commit any offence against this act may require the person to provide particulars of his or her name and address and date of birth. A constable who believes on reasonable grounds that any particulars provided on requirement under subsection 1 are false may require the person concerned to provide satisfactory evidence of the particulars. If any person without reasonable excuse refuses or fails to provide any particulars or evidence when required to do so by a constable under this section, and persists in refusing or failing after being cautioned by the constable, he or she may be arrested without warrant by any constable. A person commits an offence and is liable on conviction to a fine of not more than $2,000, who, having been required by any constable to provide any particulars or evidence under this section without reasonable excuse, refuses to fail refuses or fails to provide the particulars or evidence, or provides any particulars or evidence knowing that the particular or evidence are false in material respect. 270. Is it loading? Yeah, there we go. Further powers of police. Constable may apply for a search warrant. A constable may apply for a search warrant to search any premises. An issuing officer, within the meaning of Section 3 of the Search and Surveillance Act 2012, may, on any application by a constable in the manner provided in Subpart 3 or Part 4 of that Act, the Search and Surveillance Act, issue a search warrant to search any premises if satisfied that there are reasonable grounds for believing that any alcohol is being sold or displayed or kept for sale on any premises in which it may not lawfully be sold or displayed or kept for sale, or any premises that is being kept for or used as a place of resort for the consumption of alcohol in contravention of this act. The issuing officer may impose reasonable conditions on the execution of the warrant. 271. Search and Surveillance Act 2012 to apply. Part 4 of the Search and Surveillance Act 2012 applies to warrants issued under Section 270 and applications for them. Matters of evidence. 272. Matters of proof relating to status of premises in any proceedings for an offence against any of the provisions of this Act in relation to anything done or omitted to be done on any licensed premises, it is not necessary for the prosecution to prove that the premises to which the charge relates are or were at any material time licensed premises under at least 3 working days before the hearing. The defendant puts the question in issue by written notice to that effect served on the prosecution. In any proceedings for an offence against any provisions of this Act in relation to the sale of any alcohol or the keeping or displaying of any alcohol for sale on any licensed premises, and it is not necessary for the prosecution to provide that the premises are or were at any material time unlicensed unless that at least 3 working days before the hearing the defendant puts the question in issue by written notice to that effect served on the prosecution. Tips number 3. Matters of proof relating to content of alcohol. In relation to in any proceedings for an offence against any of the provisions of this Act in relation to any alcohol, it is not necessary for the prosecution to prove that the substance concerned contains 1.15% or more ethanol by volume at least 20 working days before the hearing. The defendant puts the question in issue by written notice to that effect served on the prosecution. 274. Evidence of sale or consumption of alcohol. In any proceedings for an offence against any of the provisions of this Act in relation to the sale or consumption of alcohol on any premises, any licensed premises or unlicensed premises, it is not necessary for the prosecution to prove that the money passed or any alcohol was actually consumed if the if the court is satisfied that a transaction is in the nature of a sale actually took place or that any consumption of alcohol was about to take place. In any proceedings for an offence against any of the provisions of this Act in relation to the sale of alcohol on any licensed premises, proof of consumption or intended consumption of alcohol on the premises or the carrying away of any alcohol of alcohol from the premises by some person other than the occupier of the premises or any person employed on them is evidence that the alcohol was sold to that person by or on behalf of the license. In any proceedings for an offence against any of the sections 244, 245, 247, 248, 255, and 256, any element of the offence relating to any person being at the time of the alleged offence is entitled to have alcohol sold or supplied to him or her, or to consume or procure it or have it in his or her possession on the licensed premises, or to be on the licensed premises or any particular part of the licensed premises must be treated as having been proved unless at least 20 working days before the hearing the defendant puts in question an issue by written notice that to that effect served on the prosecution. In any proceedings for an offence against any of the Section 239, 241 to 245, any element of the offence relating to the age of any person must be treated as having been proved unless 20 working days before the hearing and the defendant puts the question in issue by written notice to that effect on the prosecution. And the age of any person may be proved by the production of a birth certificate within the meaning of Section 4 of the Birth, Deaths, Marriages and Relationships Registration Act 2021 relating to the person, or an approved evidence of age document, or a passport relating to that person. That was a really long one. Okay. Miscellaneous provisions. 275. Liability of licensees for offences by managers. The licensee of any licensed premises is not responsible for any offence against this act committed by a manager of those premises, except where the licensee is a party to the offence. Look. Community magistrates have jurisdiction in some cases. A district court is presided over by one or more community magistrates, has jurisdiction in respect of any offence against this act that is not punishable by imprisonment. Forfeiture. Bloody seat. A constable may seize and remove any alcohol in the vessels containing it if there are reasonable grounds to suppose that the alcohol is intended for consumption in contravention of this act. On a person's being found guilty of an offence against this act in respect of any alcohol seized, the alcohol and the vessels containing it are forfeit to the Crown. Alcohol and the vessels containing it are forfeit to the Crown if it is seized by the police from a minor who is issued with an infringement notice in respect of an offence against this act alleged to have been committed by the minor's drinking it or having it in his or her possession or control it in a public place, and the infringement fee is later paid. If a person is acquitted to an offence against this act, alcohol seized under this section in relation to the offence may be collected from the relevant police station within 28 days of the acquittal by or on behalf of the person if the person's age is under the age of 18 years by his or her parent or guardian, and if it is not collected within that time, it may be disposed of in any manner the Commissioner of Police directs. Notice of prosecution or conviction of managers and licensees. Any person who files a charging document for an offence against this act against a manager of any licensed premises must send a copy of the charging document to the licensee. On the conviction of a manager of any licensed premises of an offence against this act, the registrar of the court by any by which the conviction is entered must send a notice of the conviction together with any recommendation made by the court in respect of the manager's certificate to the licensee and the secretary of the licensing authority. On the conviction of a licensee or a manager for an offence against this act, the registrar of the court by which the conviction was entered must send a notice of the conviction together with any recommendation made by the court in respect of the license to the secretary of the licensing authority, the police, the inspector, and the medical officer of health. Subpart 9. What is this? Subpart 9 is where? Yeah. It's still heaps to go, god damn it. Made it through that so far. Now we're here. Other enforcement provisions, general enforcement provisions. Building Act 2004. If an inspector believes that any building or site work does not comply with the Building Act 2004, the inspector must, by notice in writing, give to the appropriate territorial authority details of the respects in which the building or site work is believed to not comply. For purposes of this section, building, site work, and territorial authority have the meanings given to them by Section 7 of the Building Act 2004. 280. Variation, suspension, or cancellation of licenses other than special licenses. Jeez. Any constable or any inspector may at any time apply to the licensing authority for an order varying or revoking any condition of a license other than the special license imposed by the licensing authority or a licensing committee, or imposing any new condition relating to any matters specified in section 110.1, 116.1, or 117.1, suspending a license or cancelling the license. Every application for an order must be in a form approved by the chief executive after consultation with the chairperson of the licensing authority, and be made in the prescribed manner and contain the prescribed particulars, and be made to the licensing authority. The grounds on which an application for an order may be are as follows: that the license premises that the licensed premises have been conducted in breach of any of the provisions of this act or any of the conditions of the license, or otherwise an improper manner, that the conduct of the licensee is such as to show that he or she is not a suitable person to hold the license, that the licensed premises are being used in a disorderly manner or so as to be obnoxious to the neighbouring residents or to the public. The secretary must send a copy of the application to the licensee and fix the earliest practicable date for a public hearing of the application, and give at least 10 working days notice of the date, time, and place of the hearing to the applicant. And the licensee. There we go. If the licensing authority is satisfied that any of the grounds not specified in subsection 3 is established and that it is desirable to make an order under this section, it may by order vary or revoke any condition of the license imposed by the licensing authority or a licensing committee, or impose any new condition relating to or any other matter specified in section 110, 116, or subpart 1 or 117 subpart 1, or suspend the license for such period not exceeding 6 months as the licensing authority thinks fit, or cancel the license. Instead of making an order under subsection 5, the licensing authority may adjourn the application for any period it thinks fit to give the license an opportunity to remedy any matters that licensing authority may require to be remedied within that period. 281. Suspension or cancellation of licenses by a licensing authority in respect of certain offences. This section and section 282 apply in respect of an offence committed by a licensee or manager against section 237, 239, 241, 247, 2481, and 249. Or by a person not being a licensee or manager against section 2392 or 2483. A constable must immediately after the licensee or manager or person has been convicted of the offence send a report to the licensing authority. The report must include a certificate of the conviction of from the registrar of the court, of the court concerned, and a summary of the evidence on which the conviction was based, and a statement by police as to whether or not the licensed premises concerned have been conducted in the breach of any other provisions of this act, or any conditions of the license, or otherwise an improper manner, and if so, a statement of the circumstances, and a statement by the police as to whether or not the conduct of the licensee is such as to show that the license is not suitable to hold the license, and if so, a statement of the circumstances, and a recommendation by police as to whether the license or licensee should be suspended or cancelled, and the reasons for the recommendation. Immediately after receiving the report, the licensing authority must consider it. If, after considering the report, the licensing authority considers that it should hold a public hearing into whether the license held by the licensee should be suspended or cancelled, the secretary must advise the license accordingly and send a copy of the report to the police of the police to the licensee, and fix the earliest practicable date for a public hearing of the matter, and give at least 10 working days notice of the date, time, and place of the hearing to the police and the licensee. Will that be all today? Yeah. I'll do this last one. Hearing for suspension or cancellation under section 281. A certificate of the conviction included in the report of the police under section 2813A is conclusive evidence that the licensee or manager or person committed the offence referred to in the certificate. At the conclusion of the hearing, the licensing authority may make an order under subsection 3 if it is satisfied that of either or both of the following matters: that the license premises concerned have been conducted in breach of the provisions of this act, or of any conditions of the license, or otherwise in improper manner. The licensee is not a suitable person to hold the license, and it is also satisfied that it is desirable to make an order under that subsection, and an order made under the subsection is an order 2, Suspend the license for any period not exceeding 6 months as the licensing authority thinks fit, or cancel the license. Instead of making an order under subsection 3, the licensing authority may adjourn the hearing for any period it thinks fit to give the licensee an opportunity to remedy any matters that the licensing authority may require to be remedied within the period. I think we'll leave 283 for next time. Yeah. Bye.